Plaintiffs' counsel, are you ready to call your first witness?
Yes, Your Honor.
Okay. Go ahead, you may proceed.
We call Zaon Collins. Honorable Judge Anna Albertson presiding.
Morning, everyone, please be seated. Sorry for the late start. It's in my eyes, I'm trying to get it out. I'm not crying, it's some kind of weird allergy thing going on. But are we ready to proceed? Or do you guys want to do something outside of the presence?
Your Honor, there's an issue that the plaintiffs would like to raise and be corrected of.
Okay, let me call a case, put your name on the record, and then we'll discuss whatever you need to discuss outside of the presence. And then I want to make a preliminary comment before we start too. A21844-652C, the state of Echevarria versus Zaon Collins. Can I have counsel just go ahead and put their appearances on the record?
Ramzy, Ladah for plaintiff.
Joseph Chu for the plaintiff.
Stephanie Zinna for defendant Zaon Collins, and I'll be here with me is Paterno Girani.
And Tyler Watson appearing on behalf of Marvin Collins.
Okay, we did have one of the jurors ask us if we could go to lunch no later than 12:30 because for her job, she needs to do some kind of orders that need to be done before 1 o'clock. So I just want to let you guys know that we will take our lunch break at 12:30 at the latest, regardless of what's going on, and I will try to find the most appropriate place to break as we lead up to that time. Okay, what else do counsel want to put on the record?
Judge, the complaint in this case was filed November 29, 2021. The defendant filed an answer December 29, 2021. Comparative negligence or contributory negligence was not asserted as an affirmative defense in that initial responsive pleading. Plaintiff then amended its complaint, which was filed on November 2nd, 2023, to which the defendants answered the amended complaint on November 17th, 2023. Comparative negligence or contributory negligence was not asserted as an affirmative defense in that responsive pleading. It was not, the comparative negligence or contributory negligence were not raised or referenced in any capacity in the pretrial memorandum. Your Honor, under NRCP 8, subsection C, it states that a party, in responding to a pleading, a party must affirmatively state any avoidance or affirmative defense, including subsection D of that provision is contributory negligence. And there is a long history of Nevada case law hammering this point home unambiguously. For example, in Clark County School District versus Richardson Construction, a published Nevada Supreme Court case, 123 Nevada 382. It's a 2007 case. It states, under NRCP 8C, a defense that is not set forth affirmatively in a pleading is waived.
There's a whole slew of additional case law. I'm not sure we need to go into it. Your Honor, it's our position that as a matter of law that the any effort to assert comparative negligence as an affirmative defense has been waived, and it should not be referenced in any jury instructions. The jury does not need to be instructed on that defense, nor does there need to be a line in the verdict form for comparative fault. Your Honor, would like to hear anything further, I'm happy to. Otherwise, we'll submit it on that.
Okay, the verdict forms, I'll let you talk in a second. The verdict forms were agreed to or they're disputed? I don't remember.
Disputed, Your Honor.
Okay, so I have two different verdict forms.
Correct.
Okay, and the one proposed by plaintiff did not have a line for this already, or did?
I will admit my verdict form accidentally had a line for this
Okay,
because at the time I didn't realize this was not in the pleadings, quite frankly, Your Honor, to be perfectly honest.
okay.
But we needed to bring it up today. We thought it was pertinent to bring it up before. Well, to give the background, I sent stipulation on liability to Mr. Paterno and Mr. Francis Arenas. My understanding is they were going to agree. I was told they were likely going to agree, and then they never signed it. And then Stephanie told me she was going to send a stipulation. I never got it. Once she took over the case, I assumed that this was going to be waived via stipulation anyways, so I wouldn't even have to address it.
That liability was gonna be waived?
Correct.
What's the date of the operative answer?
Judge, it is November 17th of 2023.
Okay, you can go ahead and keep talking. I'm just gonna try to pull it up while you're talking. so I
And we
can
have
do it.
copies of it if you're on with like a hard copy.
I'll have if you're talking about November 17th, 2023, I've got that open right now.
Sure.
Just wanted to make sure I'm looking at the same thing you're looking at. Okay, and filed at 1:03 PM.
Yes, Judge.
Do you have a copy of this, counsel?
Copy of the answer? I do.
Okay. Okay, do you want to say anything else before I let them respond?
We thought it was pertinent to bring it up now before witnesses testify, Your Honor, before any evidence is presented.
Okay. Defense counsel, go ahead with any response.
Thank you, Your Honor, and I think I appreciate Mr. Ladah's candor in saying that they didn't realize this until just recently, because it's never been an issue that they were not aware that we were starting a comparative fault defense. And this keeps getting brought up, so I need to be very clear for this record. Mr. Ladah and our office had discussions about stipulating to liability. The parameters that Mr. Ladah proposed for that stipulation was a 3 or 4 page stipulation that went through that they were going to be entitled to essentially put on a case involving every single ounce of evidence that they wanted to put in front of the jury, despite that stipulation to liability, which we believe was inappropriate. As I was working with Mr. Ladah to potentially stipulate to liability on Zaon's behalf, we had another conversation about that in which Mr. Ladah told me that in no uncertain terms, there would not be a stipulation because a stipulation would have to be an agreement by both parties. And he did not see reason to agree to that at this time. And in fact, they even submitted a trial brief on this issue stating that there was no stipulation to liability and we were going to proceed. As to the comparative fault affirmative defense, clearly they were aware that this was a defense. It's always been a defense. They were the ones who proposed it in their jury verdict forms. They have it in their proposed jury instructions. They were aware. Therefore, there cannot be prejudice. So NRCP 15B1 states that if at trial a party objects that evidence is not within the issues raised in the pleadings, the court may permit the pleadings to be amended. The court should freely permit an amendment when doing so will aid in presenting the merits and the objecting party fails to satisfy the court that the evidence would prejudice that party's action or defense on the merits. So we have proceeded through this case with the full knowledge that comparative fault has always been at issue via responses to written discovery, via depositions. This has never been a secret. This is not something that is getting sprung on them. And in fact, they clearly stated that they didn't even realize that this was an error on the and a mistake in the pleading, because that's what it was. It was simply a mistake in the pleading, not that we were not asserting this defense. They fully believed all along throughout this litigation, throughout this trial, that we were asserting that defense. So there cannot be any prejudice to them. And if the court wants further argument or is inclined, we would request that we have a briefing on this subject, because that, I mean, quite frankly, after openings, I think we might have a real problem.
Is it alleged somewhere in the answer to the amended complaint?
We put in the answer to the amended complaint, various defenses that did include, language that Zaon was not fully at fault. There were superseding causes, for the accident, that.
Because in your answer, I got the feeling you were gonna ask for an apportionment, right?
That was, yeah, so.
I mean, sorry, in your opening, I
Right.
got the feeling you were gonna ask
Right,
for an
so
apportionment, but I'm looking at the answer and I'm not seeing if that's asserted anywhere. Do you know if it was?
I don't believe it was, and I
Okay.
think that was an error when Mr. Cannon answered this complaint. It was just inadvertently omitted. But again, if we go back to the jury instructions proposed by plaintiffs themselves, they placed an apportionment in there because, again, they believed that that was a valid defense that was already in the case. So that was their own jury proposed verdict form, their own proposed jury instructions included it. Clearly, they were on notice. 15B would apply if necessary at this point to amend the pleading to conform to the evidence. Leave should be freely given under those circumstances.
Okay, Mr. Chair.
Thank you, Judge.
Oh, if I may, Your Honor.
Oh, yeah, go ahead.
Thank you, Your Honor. Just to follow up on what Vincent is articulating, there is no prejudice. They're clearly aware of it. It's
You're
in there.
associated into this matter with Mr. Johnson, like your name's on something?
Yes.
Okay, just want to make sure. Because I did read his substitution, but I don't remember if it was just his name or his name and your name. It's your understanding your name and his name are both on it, okay?
That's my understanding. Yes, Your Honor.
Okay, go ahead.
So it's on their own jury instructions. It's on their own verdict form. Those weren't errors. That's because they understood what this case was about and this was an issue. We would ask that we be allowed to have the pleadings conform to the evidence. It's going to be presented at trial. There's going to be ample evidence of comparative fault. And there was notice within the affirmative defenses. In the first answer, there's the second affirmative defense, which states that Zaon couldn't avoid the accident. Well, the reason he couldn't avoid it was because someone pulled out in front of him.
First answer or the second
That's the
answer
first.
washes
And then-
out the first answer though, doesn't it?
Correct. And in the second answer,
So let's go with the
fourth
second answer. Go ahead.
affirmative defense says there was a sudden emergency.
Which page, which line are you on? Because the fourth affirmative defense I'm reading on page
Page 4, line,
2 is,
I'm looking, maybe I'm.
page 4, line 27 of the,
Page 4, line
answer to
27.
amended complaint, Judge.
is that where you are too as well,
No,
sir?
Page 5.
Is it Mr.
I'm
Watson?
on page 5, but my computer's frozen, so I want to make sure I'm on the right document. But yes, I believe it's page 5, line 6, the fourth affirmative defense. Answering defendant Zaon Collins was confronted with a sudden emergency and imminent peril. Am I looking at the right document?
I believe so.
Yes, I'm looking at the same document you're looking at, but
Well, that sudden emergency, which placed plaintiffs on notice of the defense, was that a vehicle pulled out immediately in front of him. That's what made it.
but there's like direct case law on that, but that's not a sudden emergency. Like that doesn't qualify, like sudden emergency is like when bees swarm your car, like if you read the cases on sudden emergency. Not when a car is on the road with you.
Well, the next portion of that answer or affirmative defense is that there was an imminent peril. It's not a B type situation. That imminent peril was the vehicle that pulled out in front of him. And again, we know that they know about this because they've included it in their jury instructions and their verdict form. And again, just to reiterate, to the extent the court is inclined to grant the relief that's being requested, we'd ask for time to provide supplemental briefing on the issue. Thank you, Your Honor.
Thanks. Plaintiff's counsel.
Yeah, Your
any
Honor,
response?
correctly noted that sudden emergency is a entirely separate legal concept. Comparative fault, as the court knows, it gives a party the opportunity to apportion liability, and if it exceeds a certain percentage, then that has consequences. That has no bearing on the sudden emergency doctrine. Ms. Zinna stated that it was omitted by error once. It was actually twice. And it was arguably a third time if we consider the joint pretrial memorandum. Our position is that that still would have been too late. But in direct response to the Rule 15 issue that was raised, consent can indeed be a basis to allow something like this and under these circumstances. But if we look at the law on this issue, I'm referring to.
Oh, you saying because you were on notice,
Right.
arguably on notice by their part, okay?
Elliott versus
Okay.
Resnick, a published Nevada Supreme Court case, 114 Nevada 25, 1998. It states, Elliott first raised the illegality issue, and illegality issue being the affirmative defense that's in dispute there that was not included in the pleadings. Elliott first raised the illegality issue in a pretrial memorandum, and Resnick did not object to its contents. In addition, Elliott put witnesses on the stand who discussed the statutes regarding the sale of a liquor license and testified as to what constitutes an illegal sale of a liquor license. making it clear that the illegality was the basis of his defense, and Resnick did not object to this testimony. That starkly contrasts with what we're talking about here, Judge. Just focusing on the pretrial memorandum, there's nothing mentioned either in the affirmative defenses section or elsewhere about contributory fault or comparative negligence. No witnesses have been put on the stand, which is partly why we're raising it right at this moment, to give testimony that is, I guess, specifically geared to that particular defense. So in this instance, it was, and no objection came from the party that that was seeking the relief that we are now seeking. There is additional case law such as Schwartz versus Schwartz, 95 Nevada 202, where it talks about the fact that even though an affirmative defense wasn't pleaded, it had been explored in discovery.
Do you want to make a record that there is no consent here from you?
There's no consent, Judge, and this issue wasn't explored in discovery. You would certainly think that if you're going to make a comparative fault argument as it relates to a T-bone intersection motor vehicle accident, when the other side hires an accident reconstruction expert, you would hire your own, or at a minimum, Judge, you would depose that accident reconstruction expert because you're trying to make a record of and build evidence to support your claim of comparative fault. So the cases where it discusses Rule 15A as being
For the record, I don't know who hired who in this case. All I know is the people that have been disclosed as potential witnesses here. You're saying there's only an accident reconstructionist on your part, not on their part.
Correct. There was none
Okay.
retained as an initial expert by the defense, none retained as a rebuttal expert by defense. And Mr. Terry, who drafted a report and supplemented his report at least once that I'm aware of, was never deposed. It was never sought for deposition. There was no discovery whatsoever done on this particular issue. And not that that would carry the day here, but these are the relevant considerations for the court in the Rule 15 analysis.
Okay. I understand why the issue's been raised, but at this time, I'm not gonna make a ruling on it. We can bring it up again later. I do think council should brief it. We can either have argument on it, or, well, actually, I think it might be appropriate to brief and have argument. When would be the soonest you think you could get a brief to me, at least with a list of the pertinent cases that you think are relevant to this issue?
We could do that by Monday, Your Honor, if needed be.
Okay, and well, if they get it by Monday, how quickly can you guys respond?
Could you give us until Wednesday?
Okay, and then the idea is we'll revisit this then shortly before closing. Okay. Perhaps even before defendant's case in chief, if we have the time to get it in. Okay,
Understood.
I think that's the soonest we can do, because I do think this issue needs to be briefed, and I think there needs to be a record of it,
Understood, Your Honor.
better than what we're doing right now.
Understood. My only concern, Your Honor, is I don't want any of the testimony I listed from witnesses to be construed as somehow waiver of or trial by consent of the affirmative defense that was never asserted, if that makes sense. So
Nothing's gonna be construed as waiver on your part. You've made your record. Now, I know probably the problem is, well, they're gonna hear some of this stuff anyway, but at this point, because it's being brought now, and because there's stuff in the record indicating that, I know you're probably not saying this, but you potentially had notice, whether it was inadvertent or whether you did have notice. It's one of those two things happening here. So they had the intention to go forward with this, which is why I think they gave the opening they gave yesterday, and why the verdict forms are proposed as they are. I'm sorry I don't have the verdict forms immediately in front of me, but I'll locate them during the next break, and I'll take a look at them to confirm they are what we're talking about. If you all have copies of your proposed verdict forms handy and you can email them to the court, that would be very helpful.
Yes, Your Honor.
Okay,
Yeah, do you want me to address that now, Your Honor? Do you want me to leave that for another time?
with the verdict forms?
Yes.
No, go ahead if you want to put something else on the record. So I'm gonna look at the verdict forms to confirm they are what you guys are saying they are, as well as the jury instructions. Does anyone know which page is the comparative instruction?
I can find that, Your Honor.
Okay, yeah, just give me an idea. And it is my understanding that you are both stating that that jury instruction is in the agreed to set, not
We
the,
are.
oh, it's not
All the liability instructions were disputed, if
in
you
the
recall,
disputed set. Okay,
because Ms. Zinna was saying she was likely going to be stipulating or waiving liability. And that's why when we went through all the liability instructions one by one, she said each of these, we probably don't need this. We probably don't need this. We probably don't need this.
okay, but she still proposed them as disputed, right? She still proposed them as disputed as part of her disputed set. I mean, do you acknowledge that or no?
No, actually, I'll be honest, I proposed them.
You proposed them.
Correct.
Okay, as part of the disputed, because she was saying that that doesn't need to be included. That's what you're saying?
I proposed them and then she said, we probably don't need those because liability is stipulated. That makes sense. Liability is
Okay, so in
probably,
the set I'm holding, are they presented to me as defendant suggested but plaintiffs opposed, or plaintiffs suggested but defendants opposed? Or
plaintiffs.
are they suggested as some kind of, depends on what happens with liability and we'll decide it then?
That's the way I saw it when I proposed jury instructions. I proposed them as it depends what's going to happen at trial. If that makes sense, Your Honor. That's the way I see it. But I proposed them, if that's what you're asking.
Okay, okay. Ms. Zinna, do you want to say something additional?
I do, Your Honor, if I may. So I want to make it very clear that when we were here at the pretrial conference, I was still in discussions with my client as to how we were going to approach this case. And I made it very clear multiple times that I did not have any agreement to stipulate to liability. And I was very cautious in the words I used. Clearly, that is not the case here. And part of that is because of Mr. Ladah's demands on the parameters for that stipulation. And I said, if we do not stipulate to liability, then of course these come in. And I don't have an objection to the law coming in if there is no stipulation or admission of liability. The jury instructions from their end have not been withdrawn. We will get you the proposed verdict forms that they proposed that had a comparative fault instruction. There is a comparative fault jury instruction at page 48 or 40 of plaintiffs proposed, and also at 41. And these were proposed by plaintiff with the understanding that however which way we approach this case, comparative fault was going to be an issue. So I appreciate the opportunity to brief it. And we will get that done. I just wanted to make it very clear that this was not I object to this jury instruction because I object to this jury instruction. I objected to this jury instruction because we still had some balls in the air on our negotiations that ultimately fell through.
Okay.
I need to clarify something, Your Honor.
Sure.
Sorry.
Okay.
At the initial pretrial conference, at the initial calendar call, before that date, I had sent Mr. Girani and Mr. Francis my proposed stipulation. Mr. Girani is here, so I'm assuming he can attest to this. After the calendar call, when the trial was set the first time, we went downstairs and I was told by Mr. Girani and Mr. Francis that they would likely be signing this. They just need final authority from their client. And that's exactly what I recall them saying. They would likely be signing this. They just need final authority from their client. Later on, Ms. Zinna comes on and I said, I sent the stipulation. They told me they'd like me to be signing this. Can you just get back to me? She said, I need to catch up on everything. I need to catch up on everything. So I assumed all along that there was not going to be an issue in the trial. Now, if I copied my proposed jury instructions from another case, I don't think that waives anything here, Your Honor, because that's a proposed jury instructions. You can propose a jury instruction. That doesn't mean it's your final record on what jury instructions you're submitting and what jury instructions you're not submitting. I think there's still time to make additional argument. And then I was told all along that liability would likely not be an issue. Now, there's two issues to liability. There's breach on the part of the defendant, and then there's breach on the part of plaintiff. That's what comparative would be. So it was unclear to me if they were going to waive their own breach or not. So for example, they could say, I'm not waiving my own breach. So liability could still be contested, if that makes sense. on their part, on the defendant. But nonetheless, I don't think the jury instructions waive anything. I had an assumption all along that liability would not be a dispute at trial, but I don't think that matters. What matters here is we have not waived the issue because no evidence has been put on. The case law is clear on that. I didn't know what they were going to say in opening. I assumed actually they were probably going to get up in opening and not contest liability in any way, shape, or form. So I just want to make the record on that.
Okay.
And I apologize, Your Honor, I do have to correct a few things. As I've stated before, I have been involved with this case before actually making an appearance, and I do recall having a discussion with both Mr. Girani and Mr. Arenas about the proposed stipulation before it even came to fruition and how we were going to tackle that strategy. And without getting into our discussions and our work product, that was a fairly recent conversation. I believe I first had that conversation within my office in February of this year for an April trial date. And then my understanding of the conversation surrounding the stipulation for liability was Mr. Arenas said, we need our client to approve this. Our client did not approve it. Therefore, it doesn't matter how Mr. Arenas felt about it. He said our client needs to approve it before we do anything. He can't bind the client to a stipulation that they don't approve to. He can only bring it back to them, have that discussion, and ultimately it wasn't. So for counsel to say that this has been all along that he felt that we were stipulating the liability, this didn't even come up until February as a potential possibility in this case. And then we were trying to work some kinks out on that. But in our discussion and myself and Mr. Ladah's discussion on jury instructions, he made it abundantly clear that he was going to object to us stipulating to liability, even if we proposed a stipulation or proposed an agreement at that point and proposed these jury instructions, and we went through them. And I said, I don't have a problem with these as long as I don't know where we stand on the stipulation of what we're going to do. And we had some words exchanged about whether or not we were stipulating, agreeing, whatever. Mr. Ladah felt very strongly that he would not stipulate to liability no matter what I proposed at that point, and he was moving forward. He proposed these instructions to me, and I continued with those are fine if we can't get to an agreement. So these were his proposed. He proposed the verdict form. I made some tweaks to it, but kept it very much in the same vein. And so to say that all along we were going to stipulate to liability is unfortunately is not accurate. But I understand, and I will stop there making the record because I understand we're going to brief this issue.
Okay. Anything else?
For the sake of time, Your Honor, there is some things that I disagree with what she said, but I'll save it for later.
I imagine there's disagreements on both sides as far as the representations made by both sides in here right now. At least that's what I'm hearing. And I just want to be clear, what I'm understanding this to be is you're trying to preclude them from making the argument that there's some kind of comparison here where it would reduce your client's damages, right?
Correct, Your Honor.
Okay. Okay, with that being said, anything else before we bring them in and start witnesses?
Just one additional matter, Your Honor, that should be quick. I know that plaintiff intends to call Zaon adversely. I do not intend on doing my direct with him today because for the sake of time, I know that plaintiff has a lot of witnesses lined up. But if I do need to ask him a couple of questions, I just want to ensure that I don't wait the right then to recall him in my case in chief.
Have you guys talked about this? You understand that she plans on calling him again in her case in chief?
Yes, I don't believe she's waived her right.
Okay. Okay, anything else?
No, that's it.
Okay, thanks, guys. I think they're all here. They're all here. We'll just go ahead and get started.
I wanted to make a record, Your Honor, real quick. Our expert, Mr. Terry, is in the courtroom because we don't believe the exclusionary rule applies to experts. And there is relevant things that may come up with respect to how the accident, he claims the accident occurred.
No objection.
And he's going next, so logistically, so.
Should come in a second. Because of the lunch requirement, that we take a break so that one of the jurors can do what she needs to do work-wise during lunch. We I might ask them if they're willing to power through the morning break. With the hope that we can get close to 2 hours done before we go to lunch. But we'll see how it's going. Please be seated. Ladies and gentlemen, welcome back. I'm going to initially just, I'm having a little bit of an allergy eye issue today. So, if I'm tearing up, if I'm scratching my eyes a lot, if I look frustrated, I don't want you to imply that I'm frustrated with any counsel or anybody's position. It really is just my eyes are extremely irritated. And I wanted to make sure we kept going so that we didn't lose time here. Especially because as I said yesterday, we are going at a good pace to get done where we said we were going to get done. With that being said, counsel, will you acknowledge the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. Plaintiffs' counsel, are you ready to call your first witness?
Yes, Your Honor.
Okay. Go ahead, you may proceed.
We call Zaon Collins.
Mr. Collins?
Remain standing.
You just raise your right hand and look over at my clerk.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pain and penalty of perjury. Please state and spell your first and last name for the record.
Zaon Collins, Zaon Collins, Collins.
Thank you. You may be seated. Be sure to pull that microphone that's right in front of you, pretty close to you, and then make sure that little red button is up in the on position.
Good morning, Mr. Collins.
Morning.
How are you today?
I'm good. You?
Good, thank you. I'm not going to take up too much of your time today, okay? You were born on September 10th of 2001.
Yes.
That makes you 24 years old today?
No.
Oh, sorry, how old are you? My
Oh.
math is bad.
I'm 23.
23, thank you. At the time of this crash that we're here to talk about today, you were 19.
Yes.
Okay, which means you were an adult when the crash occurred.
Yes.
Thank you. When the crash occurred, you were on your way to basketball practice.
Yes.
At that time, you lived at your mother's house.
Yes.
And your father and mother lived separately at that time.
Yes.
You never slept at your father's house?
No.
Your mother's house is right around the corner from where the crash occurred.
Yes.
In other words, it's close to where the crash occurred.
Yes.
I want to talk about your driver's license for a little bit, okay?
Yep.
Start with your permit. You got your permit when you were 15 and a half.
Yeah, whenever I was able to get it, as soon as I was able to get it, I got it.
Do you remember getting it earlier than 15 and a half?
No.
Okay. Does 15 and a half sound right?
Yes.
Okay. You got your license when you were 16?
Whenever I was able to get it.
Do you remember how early that was?
It was just whenever I was able to get my driver's license after getting my permit, I got my license.
May we publish Zaon Collins' deposition, Your Honor?
Any objection?
Yes, I don't understand the purpose of impeaching him on a driver's license issue.
2 reasons, Your Honor. Deposition of a party can be used for any purpose. And second of all, I just need to refresh his recollection on when he said.
Show it to him. If you just want to show it to him, you can show it to him without even publishing it.
Like,
Are you showing it to refresh his recollection about something that he said previously?
yes, but I'm also trying to use it for it can be used for any purpose. So I'm trying to use it for the purpose I think is effective here, Your Honor.
Position is this is an improper purpose, Your Honor.
Okay. Do you have the deposition on you?
Yes, Your Honor.
Do you have the section you want to read?
Yes, I do.
Why don't you just bring it up? Or why don't you show it to opposing counsel and see if that there's still an issue?
Page 10, 18 through 22. Just confirming the date. Sixteen. Okay.
So I don't understand the purpose.
Do you want to make that argument to the judge or? Should we approach, Your Honor?
Sure. Okay, that's fine. Then go ahead.
I move to publish the deposition, Your Honor.
Okay, pursuant to what we discussed up here, it can be published. Go ahead.
May I approach?
Yes.
Thank you. And Zaon, at times I may refer to some things in your deposition just to make sure we're on the same page for everything, okay?
Yes.
Okay. I want you to go to page 10 of the deposition, if you don't mind.
Where are the page numbers?
Sorry?
Page numbers?
Top right corner. Tell me when you can see them. I'm going to read lines 18 through 24, okay?
Yes.
Okay, thank you. When did you get your driver's license, Zaon? Answer, the earliest you can get it, I think it's like 15 and a half. Permit 15 and a half. License 16. Did I read that correctly?
Yes.
Does that refresh your recollection that you got your license when you were 16?
Like I said, like whenever you can get your license after you get your permit, that's when I got my license. So
Okay. Would it have been earlier than you were 16?
I'm not sure. Whenever you can get your license, I got my license whenever I was able to.
Got it. Thank you, Zaon. When you obtained your permit, Zaon, were you required to have someone else in the car with you when you drove the vehicle?
Yes.
Who did you drive with when you got your permit?
My parents,
Mom and your dad?
either or.
Would it be both?
I don't remember.
Question is, once you got your permit, was there any point when you drove with your dad, when you were driving, your dad was in the passenger seat?
Yeah.
Okay.
Yes.
Thank you. Who taught you how to drive, Sam?
My parents,
Mom or your dad or both?
my parents, both.
Both. Thank you. You were given a number of driving citations in between when you got your permit and when this crash happened. Is that correct?
Can you say that again?
Yeah. Citations are like a traffic ticket. Does that make sense?
Yeah.
So you were given a number of traffic tickets between when you got your permit and when this crash occurred.
Yes.
Okay. Do you remember when I asked you that question in your deposition?
No.
Okay, let's look at your deposition at page 19. Just want to clarify. Going from page line 3.
Objection again, this is improper impeachment, this is not a proper use.
What's it being used for?
It's being used to go over what he said in his deposition, and the rule says I can use the deposition of party for any purpose, Your Honor.
Okay. Go ahead.
Thank you. All right, tell me if I read this correctly, okay, Zaon? From line 3, it says, okay, do you have any speeding tickets or other type of traffic tickets before December 30th of 2020? Answer, yes. Question, okay, how many? Answer, I don't know the exact number. Question, were they speeding tickets or other type of tickets? Answer, they were speeding tickets. Question, how many of them were there? Answer, I don't know the exact number. Did I read that correctly, Dan?
Yes.
Okay. As you see here today, do you know how many tickets you received in between when you got your permit and when this crash happened?
I really can't answer like yes or no. I know the exact number, but not that many.
Okay.
Not that many at all.
Okay. I'm going to go over them, okay, just to make sure we're on the same page. You got your first traffic ticket on 11/27 of 2017, correct?
I don't know the exact date.
Okay, I'm going to pull that up. Can we pull up Exhibit 17, 1, please, Joe? Can you give us the date, please? You see that date there, Zaon? Oh, I'm sorry. Do you prefer me call you Mr. Collins or first name, Zaon? What do you prefer?
Either.
Okay, thank you. Do you see the date there on the screen?
Where?
Oh, he's highlighted it up at the top.
Okay.
Can you read that date?
11/27/2017.
Yeah, I think it actually comes up on your screen as well, if you want to just look on your screen. Do you see it there? Oh, it's not. Okay. All right, so this would have been, tell me if my math is wrong, but this would have been 2 months after about 2 months after your 16th birthday?
I would just object that the witness should be allowed to see the entire document before answering questions about it.
You can show them the entire document. Can you show them the entire document?
Yeah, do you want me to hand it to him via the exhibits?
Yes, please.
Sure.
Your Honor, may I,
We're gonna get you the full document, okay, Zaon?
Grab one at a time if they're too heavy. And just put them on the table and ask, yeah, right in front of you, and as council references.
There, so maybe we can give you the exhibit number and the bait stamp page, rather than you having to twist your whole body so that you can be looking at the same thing they're looking at.
Okay.
And if you go to tab 17, Zaon, I know there's a lot there, so.
Permission to approach, Your Honor. I want to get the second binder out of the way.
Yeah, go ahead. Yeah. As long as, and look, Zaon,
Yeah.
Mr. Collins, if at any point somebody gets too close to you, just let us know. And that's gonna be true of all the witnesses that take the stand. So please tell your witnesses and your clients that the same thing goes for them. People can come up and help you, but if at any point you feel like someone's invading your space, just say something right away, please.
Okay.
That's the document. Do you see it there?
Yeah.
Okay. And you see the date now?
Yes.
And that's 2 months, well, I guess a little more than 2 months after your 16th birthday, is that correct?
Yeah. Like close to 3.
Almost 3 months, okay, fair enough. So less than 3 months after your 16th birthday, after you first got your license, you got the first ticket, correct?
Yeah.
Okay. And this ticket was for, can we find down below what it says it's for? Failure to pay full attention. Do you see that, Dan? You can also refer to the screen if you want, because we're highlighting it, but whatever is better for you.
Yeah, I see.
You agree the ticket is for failure to pay full attention?
Yes.
Okay. You did in fact receive this ticket, right, Zaon?
What do you mean?
You did receive this ticket, correct?
Yeah.
Okay. In other words, someone,
Okay, hold on. When you respond, we do need you to just speak clearly and loudly into the microphone as best you can.
Mm.
Stephanie, are you able to hear him? Okay. So just as best you can, speak clearly and loudly into the microphone, okay? Because I'm having trouble hearing you, and if he's hearing you, it's okay, because at least it gets on the record, but if I'm having trouble hearing you, it's likely that some of the judges are having trouble hearing you too, because I'm even closer to you than they are, okay?
Okay.
Thanks.
all right, I'm gonna go over your next ticket, okay, Zan?
Yes.
Let's go over 17-003, please, Joe. And the date of this one is 9/20/18, correct, Zan?
Where is that?
Oh, this is 17-003. And the numbers are at the bottom right-hand corner.
Yes.
And you can see that one there. It says speeding 21 to 30 over the speed limit, correct?
Yes.
Okay, thank you. You can take that down, Joe. So that was your first speeding ticket, correct?
Yes.
Okay, thank you. Let's go to the third ticket. This is 17-005. Pull up the date, and this one is 11/20/18. Is that right? Just tell me if I'm saying the date right.
Yes.
Thank you, Dan. And why don't you tell us what this ticket was for?
Speeding.
How fast?
Speed of 90 miles per hour.
In 90 miles per hour in what zone?
65.
65-mile-an-hour zone, right?
Yes.
You would agree driving that fast on the public roadways is dangerous?
Yes. Yes.
You agree?
Mhm.
All right, let's go over the next tickets, Ann, if you don't mind. This is going to be 17-007. Let's go over the date first. What's the date of this ticket, Zan? I've got it highlighted on the screen if you want to look, but you're free to look on your binder.
6/19.
6/19 of what's the year?
2020.
Great. And what was the citation for?
Drive wrong way on one way street.
Okay. Do you remember getting these tickets, or do you not remember?
I remember this one. It was like an island, and it was like a brand new store. So,
Okay.
Yeah.
Do you remember the speeding ones that we just went over, or do you not remember those?
It was so long ago. I don't remember.
Got it. Okay. And then after this one, our crash occurs on December 30th of 2020, correct?
Yes.
Okay, thank you. Now, do you remember saying in your deposition that you don't really remember the crash that well? You remember saying that?
No, I don't remember.
Let's go over it, okay? Let's go to your deposition at page 9, if you don't mind. And I'm going to go through the bottom of page 9 from page 22, from line 22 over to page 10, line 3, okay? Tell me when you're there and you can follow along with me. Oh, it's the deposition you want to go over this time. Remember the deposition book?
This one?
Yeah, you got it. Thank you. Page 9. I'm going to start from line 22. I'm going to read through the end of this page and go on to the top of page 10 to line 3. All right? If you want to follow along with me, if you don't mind. Okay, question. Okay, how well do you remember the crash and the 5 minutes leading up to the crash? Answer. Leading up to the crash, I mean, I don't remember. I probably was just leaving home and then the crash. Really don't remember the crash that good either. I know what happened right before the crash, and then that's pretty much it. Did I read that correctly, Zaon?
Yes.
Okay, thank you. Do you remember the crash better today or about the same or worse?
Like I said, I remember what happened before the crash. That's pretty much it. Like,
Okay.
I remember getting out the car, checking on the other car, and that was it.
That's all you remember from the crash?
Yeah, I don't remember what happened after.
Okay. When that crash occurred, Zaon, you were driving a gray Dodge Challenger, correct?
Yes.
And that gray Dodge Challenger you were driving is the same as this car that we're going to show in 17-001. Oh, 17-007, I'm sorry. Can you find where it says the car? So this is the ticket, the most recent ticket you got before the crash, Zaon. It's the one where you were cited for driving the wrong way in a one-way. Remember that?
Yes.
Okay. Can you see there what it says, which car you were driving when you got that ticket?
What,
Oh, I'm sorry. Top left where we've highlighted, it says vehicle license. What's the vehicle license there?
the license says ZSLUM.
That's the Dodge Challenger, right?
Yes.
And it says it right there over to the right where we've circled as well, correct?
Yes.
And that's your dad's Dodge Challenger, correct?
Yes.
Okay. The license plate to that Dodge Challenger is a personalized plate, in other words, right?
Yes.
Okay. And it was owned exclusively by your father, Marvin Collins, correct?
Yes.
Okay. He's the only one that owned that vehicle, correct?
Objection, Your Honor calls for speculation, Max Foundation.
I can ask if he's aware, Your Honor.
Go ahead.
Are you aware of anyone else? Are you aware of anyone else owning that vehicle?
No.
Thank you. You remember in your deposition when I asked you what the license plate of that vehicle was, you said you couldn't remember. Do you remember that?
Yes.
Okay. I want to go over that just to make sure. Let's go to page 29. And I'm going to read from lines 18 through page 30, line 1, okay? You want to follow along. Tell me when you're there. Yeah.
I'm here.
Okay. Line 18. Question. Okay, what's the license plate of that Dodge Challenger? Answer. I can't remember. Question. Okay. Can't remember at all? Answer. No. Question. Is it Zaslum? Answer. Zaslum. Yeah. Question, it is? Answer, yeah. Did I read that correctly?
Yeah.
Okay. I want to go over and make sure this is the same license plate we're referring to. Can we go to 7-048, please, Joe? Can you see the license plate there in the picture?
Yes.
Okay, that's the same personalized license plate we're talking about.
Yes.
Okay. Let's go to 7-049, please, just make sure. That's it there as well? Yeah,
Yes.
okay. And then 7-059? Oh, well, that's okay. We got the idea. In other words, that's the car you were driving, right, Zaon?
Yes.
Okay, perfect. Where does the Z slum come from that it says on the license plate?
There's Z, my first initial, and it was just me and a couple of my cousins. We just was like, let's get the same Instagram name, so we just made Z Slum. That was just like my nickname.
Got it. So that's your nickname.
I mean, no one called me Z Slum or like Slum or nothing like that. Like they call me Zay.
Jay, okay.
Yeah.
Got it. All right. And you have the same Instagram handle?
Yeah.
Great. Thank you.
Yes.
Your dad told you to pick the personalization of the plate, correct?
He didn't.
Objection, leading.
It's adverse witness, Your Honor.
Overruled.
Go ahead, Zay. Or Zayon, I'm sorry.
I can't remember if it was like just like he did it just to do it, or he asked me to, but I remember he just did it one day.
Okay.
Probably asked him to do it, and he just probably did it. I don't remember.
Okay. I want to go over what you said in your deposition, all right?
Yeah.
Let's go to page 30. I'm looking at lines 8 through 11. Tell me when you're there.
30.
Yes.
I'm here.
Actually, let's start at line 2, okay?
Yes.
So I say, question, what is Zay slum? Answer, it's just Zay for me like Zay. Question, what do you mean for you, Zay? Answer, like my name is Zay. Question, okay. Answer, he told me to pick the plate, anything I wanted, and I said Zay. Question, why did he tell you to pick the plate? Answer, can't remember. Does that refresh your recollection that your dad told you to pick the plate?
Yeah.
Okay, great, thank you. You know you were under oath in your deposition, correct?
Yes.
Thank you. And under oath means you swear to tell the truth, the whole truth, and nothing but the truth, correct?
Yes.
Thank you. How often did you drive that Dodge Challenger, Zaon?
When I wasn't driving the car me and my sister shared, I was driving that one, or like I was getting taken to school and practice and stuff like that by my mom.
Can you give us a better idea how often you drove that Dodge Challenger?
I don't remember, like a couple times a week, probably, like not a couple, but like throughout the week I would drive it if I wasn't in the other car.
Throughout the week you would drive it if you weren't in the other car?
Yes.
Okay. So would it be more than a couple times?
Yeah, throughout the week, yeah.
Throughout the week?
Yeah.
Okay, so you drive it often?
Like he would drive it more throughout the week than me, but yeah, I would have it probably three, 4 times, 3 times probably.
Okay, thank you. Do you remember answering interrogatories, Zaon? There were written questions.
No,
You don't remember the written questions that were sent to you?
no, I do not.
May I approach with his interrogatory response, Your Honor?
Yes.
Which document are you showing?
This is supplemental answers.
Thank you.
Can you look at page 21 for me, please, Zaon? I'm going to read the question and answer, and you tell me if I read it correctly, okay?
Yes.
Okay. Interrogatory number 26. If you were not the owner of the vehicle you were driving in the subject crash, please identify its owner, stating the relationship to you, whether you had permission to operate the vehicle, the purpose for which you were operating the vehicle, and how you came to be driving the vehicle. Answer number 26. The registered owner of the vehicle I was driving on the day of the incident was my father, Marvin Collins. I had my father's permission to be driving his vehicle to travel to and from school and to use for my other daily activities. Did I read that correctly?
Yes.
Okay. Is that accurate as you look at that now?
Yeah, he would let me drive the car throughout the week.
Okay. Do you remember signing the verification to this?
No.
There's a verification page in there. Do you want me to find it for you to make it easier?
The page number?
It's labeled page number 1, but it's with it. It should be at the back though. This is what it looks like. It's I think you got it right
Two
there.
different ones.
What's that?
Two different ones.
Oh, I'm looking for the one that says verification on the top.
Yeah. I
See that? Can you read what it says under the verification section for us, please?
Zaon Collins, being duly sworn according to the law, deposes and says that he has read the foregoing defendant Zaon Collins supplemental answers to plaintiff Anne Marie interrogatories. I don't know how to pronounce that.
That's fine. You're good.
Sure.
Does that
Keep
have your,
going.
yeah, keep going, please.
Knows the contents, therefore, and that the same are true to the best of his knowledge, except as the matters therein set forth upon information and belief, and as those matter he believes to be true.
Does it have your signature there?
Yes.
And is it notarized?
Yes.
Okay. Do you recall signing this?
Don't remember, but my signature is there.
Okay. All right. Zaon, when the crash occurred, you were heading to basketball practice, we established, right?
Yes.
You were not late to basketball practice, correct?
No.
Basketball practice started at 4 o'clock that day, correct?
Yes.
And the crash occurred shortly after 3 o'clock that day, correct?
Yes.
In other words, you had plenty of time to get to basketball practice, correct?
Yes.
You did not need to speed to get to basketball practice, correct?
Yes.
Thank you. It's about a 30-minute drive from your mom's house to where basketball practice was, correct?
Yes.
Under normal driving conditions without speeding, correct?
Yes.
Thank you. And this crash that we're here to talk about today occurred at the intersection of Fort Apache and Furnace Gulch, correct?
I'm not familiar with the names of the street.
You're not familiar with the Furnace Gulch Street.
I'm familiar with the streets. I just don't know the names that well.
Got it. I'm assuming you know Fort Apache though.
Yeah, I know Fort Apache.
It's a major street and you took that street off, and I'm assuming. Is that fair to assume?
What do you mean by that?
You drove on Fort Apache often,
Often.
like commonly, regularly.
Yeah.
Okay,
Yes.
thank you. Thank you, Zaon. And your mom's house is only about 6 minutes away from where the crash occurred, you said, correct?
I don't know if I said that, but
Let's pull out your deposition. You can go to page 25 for me, Zaon.
I'm here.
I'm looking at lines 20 through 22, okay?
Yes.
Question, how long is the drive from your house to the scene of the accident roughly? Answer, I would say about like 6 minutes. Did I read that correctly?
Yes.
Okay. Would you agree with that now, today, or do you have a different answer?
I agree.
Okay, thank you. So what street would you have turned onto Fort Apache from when you left your mother's house that day?
I'm not familiar. I don't know the street name.
Would it have been LeBaron?
I can't tell you.
Okay. Either way, you would not have been on Fort Apache very long when the crash occurred, correct?
Which one? I really don't even know Fort Apache.
Fort Apache is the straightaway street where the crash occurred. That makes sense?
Yes.
Because you were driving straight, right?
Yes.
So it's the street you were on when the crash occurred.
Okay, so ask the question again, please.
You would not have been on Fort Apache very long when the crash occurred.
I believe Fort Apache is what made it, like the 6-minute drive, probably.
I'm sorry?
Fort Apache, it's longer on Fort Apache than it was on the side street.
Got it. So you were on Fort Apache longer than you were on the side street that you took to get from your mom's house to Fort Apache is what you're saying.
Huh?
So let me ask this. How long did it take to get from your mom's house to Fort Apache?
It's just a turn.
This turn. So maybe a minute,
Yeah, give or take.
which means you would have been on Fort Apache about 5 minutes prior to the crash. Is that fair?
Yeah, but I'm not sure. I'm not sure.
Okay. You told the officers at the scene of the crash that you were going about 45 to 48 miles per hour leading up to the crash, correct?
I don't remember.
Okay. We're going to pull that up. Can we pull that up, Joe, please? That's clip number 1. See that?
Yes.
Okay. Do you agree now that you told them you were going about 45 to 48 when the crash occurred?
Yeah, I see that, but I don't even remember saying none of that.
Okay.
Yeah.
Understood. You know you were speeding when you were driving on Fort Apache, correct?
Yeah, I know I was speeding. That's why I'm here to take responsibility for my part.
Okay. And you have no idea how much over the speed limit you were going that day.
Say it again.
You have no idea how much over the speed limit you were going that day.
What do you mean?
Do you have any idea how fast you were going that day, Zaon, as you see here today?
Yeah, I was speeding that day. Yes.
The question is how fast?
It says I was going 88 miles per hour.
Thank you. And you're aware, as you see here today, what the speed limit was on Fort Apache?
Yes.
What is the speed limit?
35.
Thank you. You knew the speed limit on Fort Apache was not 85, correct?
Yes.
Thank you. Let me ask you this. We've already established that at some point, once you get on a Fort Apache, before the crash occurs, you're going 88, correct?
Say it again.
At some point, when you're driving on Fort Apache, before the crash occurs, you are driving 88 miles an hour, correct?
Yes.
Okay. Did you get up to 88 very quickly? In other words, when you got on Fort Apache, did you jam on the gas and get all the way up to 88 fast? Or did you gradually get up to 88?
I didn't smash no gas, like I didn't do none of that. I was just driving and it was a car in front of me. So like, I really didn't notice how fast I was going. So the car to the left of me wasn't really, I wasn't really gaining on that car really. So I really didn't know how fast I was going. Um,
The car ahead of you was going the same speed as you.
I never said that.
Sorry?
So I did not say that.
Okay. Let's take a look at that. Let's go to your deposition, Zaon, if you don't mind, please. And let's go to page 38, lines 14 through 17, okay? You're saying here today that you never said the car ahead of you was going the same speed as you, correct?
Objection to state's testimony.
Response.
I'm asking the question to clarify, Your Honor.
Okay, overruled.
Did you say here today that you never said the car ahead of you was going the same speed as you?
I never said that. I never said that. I don't remember if I said that. You asked me if the car was going the same speed, and I said I did not say that as of right now.
Okay. All right, so let's go over that if you don't mind. I'm on page 38. I'm starting on line 4, okay?
Yes.
Question, okay, and you were in the right lane, question mark? Answer, right lane. Question, okay, there was another car in the left lane? Answer, left lane. Question, in the same direction as you? Answer, same direction. Question, how far ahead of you was the car in the left lane in the same direction as you? Answer, I don't know. Question, okay, but you know it was ahead of you? Answer, it was ahead of me. I could see it. It was right. Same speed ahead of me in the front. Did I read that correctly?
Yeah. Yes.
Same speed means you were saying the car ahead of you was going the same speed as you, right?
I'm not sure what I meant by that, but like I said, I was just focused on the road. I didn't realize I was going that fast.
Okay, no problem. All right. Let me ask you this. You weren't in a hurry that day, right?
I was not in a hurry.
So you were just speeding for fun?
Objection, Your Honor, argumentative.
Oh, state.
Let me ask it this way. Were you speeding for fun?
Objection, Your Honor, argumentative.
Sustained.
Why were you speeding, Sam?
Like I said, I just didn't realize I was going that fast.
You agree that 88 miles per hour in a 35 is unreasonable, Sam?
Objection, Your Honor. Calls for a legal conclusion form.
Sustained.
Do you agree that going 88 and 35 is dangerous?
Same objections, Your Honor.
Have counsel cards, please.
All right, Zaon, the question is going 88 and a 35 dangerous?
Yeah, going 88 and 35 is dangerous. People can get hurt.
Thank you, Zaon. What are the reasons why going 88 and a 35 are dangerous?
People can get hurt, and it's you know, it's not what you do. It's not what you're supposed to do.
You agree it's harder to slow down if you're going too fast, right?
Just say it again.
It's harder to slow down if you're going too fast.
Yes.
It's harder to stop quickly if you're going too fast.
Same. Yes.
It's also harder for other vehicles to judge your space if you're going too fast.
Objection, Your Honor, calls for an expert opinion and a legal conclusion.
To the extent he can answer, it's overruled.
I don't remember the question.
It's harder for other vehicles to judge their space between them and you if you're going too fast on the roadways.
Don't answer just yet. Just think about your answer. Your objection still stands, right?
Correct, Your Honor.
And my ruling still stands. It's overruled. To the extent this witness has the ability to answer that question, he's able to answer the question. Go ahead and answer the question if you can.
Can you repeat it one more time, please?
Okay. Then rather than us go through this process again afterwards, we're just gonna have the objection set, okay? Ask your question and your objections on the record.
It's harder for other vehicles, other drivers to judge how much space they have in between them and you if you're going too fast.
Well, if you can see the car, you can tell, like, if you have enough time and space, you know.
Okay. And also, a crash at a higher rate of speed is going to be more dangerous than a crash at a lower rate of speed. Would you agree with that?
One more time, please.
A crash at a higher rate of speed is going to be more dangerous than a crash at a lower rate of speed.
Yeah, to an extent, yeah, because you can be going 60 and something bad can happen, like this accident.
Thank you, Zaon. If you were going slower, Mr. Echevarria would have had more time to get through the intersection, correct?
Objection, Your Honor, calls for speculation, calls for an expert opinion.
Going.
This was also in the deposition, Your Honor. There was no objection.
Objections as to expert opinions are not waived. They're actually improper deposition objections.
Do you want to say anything else?
I think it's a form objection that needs to be made, Your Honor.
Overruled.
Do you want me to ask the question again, Sam?
Yes, please.
Okay.
Okay, objection still stands.
Yes, and I
If
won't
you-
interrupt.
Okay.
If you were going the speed limit, if you're going slower, Mr. Echevarria would have had more time to make it through the intersection before you hit him, correct?
I'm not sure.
Okay. Do you remember what you said in your deposition?
No.
Let's go to that. Let's go to page 59. Sorry, 58. Looking at line 22, okay? And I'm going to go on to the next page, all the way to line 7. All right, Zaon? Okay.
Yes.
Hold on a second before you start reading.
Yeah.
I'm gonna ask you, because I don't know, is your objection to these questions too?
Yes, Your Honor, it goes to the same.
Okay, and the basis for the objection is what again?
All of this calls for an expert opinion as to whether or not Mr. Echevarria would have had time to turn, and that is the direct issue that one of the witnesses will be testifying to. this is a lay witness. He doesn't know how to calculate those times.
Okay. I don't think he's asking for an exact time or that calculation. Any additional reason for objecting?
No, Your Honor, I'll stand by that objection.
And Counselor, you also raising that objection. Did you say objection to? I don't remember. I'm sorry.
Yeah, I join.
Okay. Do you have any additional reason other than what's already been stated?
I do not, Your Honor.
Okay, on that basis, overruled.
Thank you. All right, line 22.
I'm not asking for an expert opinion. I just want to be really clear about that. You're just asking of his opinion based on what was happening in the circumstances.
Thank you, Your Honor. Zaon, line 22, I'm going to start there, okay? Question, okay, you agree that when someone is driving and going to turn left, cut across traffic, they have a reasonable expectation that the cross traffic, which is you, answer yeah. Question, are going to be following the speed limit and not driving above the speed limit? Answer yes. Question, you agree? Answer, I agree. See that, Zaon?
Yes, I see that.
Do you disagree with that now?
I mean, I don't remember that, but yeah,
You agree?
somewhat, yes.
Are you going to change your testimony or are you going to stick by the testimony you gave in the deposition?
I'm sticking with testimony.
Sticking with it.
Yeah.
Okay, thank you. Zaon, if you were going the speed limit, Mr. Echevarria would have made it through the intersection and onto Furnace Gulch without an impact, correct?
Objection, Your Honor, calls for an expert opinion.
Objection also calls for speculation.
And I'll join that.
You want to respond?
I'm not asking for an expert opinion. I'm asking based on his perception. And this is important for, based on what he said in his deposition, Your Honor.
On the basis that it's speculative, it is sustained.
Okay, thank you, Your Honor. Zaon, you agree your speeding is the cause of this crash, correct?
Objection calls for a legal conclusion, calls for speculation.
Are you objecting to? Or
I'll
just
join.
Overruled.
You want to ask it again?
Yes, please.
You agree,
Objection stands. My ruling stands as long as the question is exactly the same, just because I don't want to confuse you, sir. I don't want to get you in a situation again where he's asking a question and then we're going through this all again and then you can't remember the question, okay? So your objection still stands, as long as the question is the same question.
Okay.
Go ahead, sir.
Zaon, you agree your speeding is the cause of this crash.
My speeding is part of what caused this crash, this accident.
So you agree your speeding partially caused this crash, at least that's your admission, right?
Yes.
Okay, thank you. And as you're heading northbound in Fort Apache, as you approached Furnace Gulch, there was another car ahead of you, you're saying, correct?
Yes, to the left of me.
And you claimed in your deposition that that car was going roughly the same speed as you, correct? Or are you changing that now?
Objection asked and answered.
Overruled.
Are you changing that now, is the question?
Changing what?
The same speed. Remember you said the car in front of you was going the same speed as you? Are you changing that testimony? Or are you sticking by it?
No, I'm not changing anything. Like I said earlier, don't remember.
Okay. And according to you, everyone goes over the speed limit on that road, right, Zaon?
According to me?
Yep.
When did I say that?
You want to go through the deposition? I can do that.
Yes, please.
Let's do that, Zaon. Sorry. Let's go to page 36, okay?
Mayor.
Lines 4 through 14, okay?
Yes.
Question. How do you know you were going over the speed limit if you don't remember how fast you were going? Answer, because I don't know. Everyone goes over the speed limit on that road. Question. So the way you know you were going over the speed limit when the collision occurred is because everyone goes over the speed limit on that road. Is that correct? Answer. Yes. I believe so. Yes. Did I read that correctly?
Yes.
That was your under oath testimony, correct, Zaon?
Yes.
Okay. Are you changing that now? Are you sticking by it?
I'm sticking by it.
Did you know there's a video that we have that shows the lead up to the crash?
Yes.
Okay, have you seen it?
Yes.
When did you first see that video?
Um, in the beginning of my criminal case.
Okay. Let's go over it. If let's watch it again. I want to ask you a couple questions. Can we play that, please, Joe? Exhibit 12. All right, you can pause it right there. Are you saying you were not catching up to the car ahead of you, Zaon?
I really don't remember.
Okay. Can you see now in this video that you were catching up to the car ahead of you?
Like, yeah.
Can you see now in this video that you're going much faster than the car ahead of you?
Yeah.
Okay, thank you. Are you aware that our accident reconstruction has said that the car ahead of you was only going 40 in this video?
No.
Okay. So why did you try to say in your deposition the car ahead of you was going the same speed as you?
I don't know. I'm not an expert. I can't tell how fast car is going.
Okay. In your deposition, you claimed you were in the right lane leading up to the crash. Do you remember that?
Yes, I was in the right lane.
Okay. Let's go over that. Can we show the video one more time? Can you take a look at it and tell me what lane you're in? You want to watch it for us, please, Zaon? Thank you. Oh, it looks like it froze. But right there, what lane are you in? Right lane or left lane?
Right there is still one lane.
Okay. Still one lane.
So then when they break into two lanes, I get in the right lane.
Okay. How long before the crash was it that you broke into the right lane?
Not sure.
Would you agree it was right before the crash that you swerved at the last second into the right lane?
Objection, Your Honor. Form, lacks foundation, argumentative.
Join.
I'm going to respond, Your Honor.
Yeah, what's your response?
He was there at the scene. I'm asking him if he
So your
agrees.
response is personal knowledge?
Correct.
Okay.
If I may object to this swerve.
Oh, you're objecting to the word swerve?
Yes, Your Honor.
Oh, okay.
There's no evidence in this case that illustrates he swerved.
Can you repeat your question? I'm sorry.
You agree that at the last second you swerved into the right lane.
Okay, overruled. You can ask the question.
I'm going to ask again.
No, I heard you. No, I didn't swerve into the right lane. I was in the right lane. There was a car to my left, and Mr. Eric tried to go in front of the first car on the left, and he stopped really hard on his brakes. And then he cut right in front of me.
Okay.
And then I couldn't do anything to avoid the accident.
So your testimony, tell me if I'm wrong, your testimony is Mr. Echevarria stopped in the middle of the intersection.
Yeah, he was right. He was in the other lane. He stopped right like that. Yeah.
In the intersection.
Yes.
Thank you. Do you know how your car and Mr. Echevarria's car ended up through the wall after the crash occurred? Or do you have no recollection of that?
What do you mean by that?
Foundation.
Are you
Join.
okay? Let's show a picture then.
Okay, so you're withdrawing the question?
Yeah, I'll withdraw the question, Your Honor.
Okay.
I'll make
Then
it.
I'm
I'll
not
make it
making a
easier.
ruling on the objections.
Let's go to. Can we pull up one of the pictures of the car on the wall, Joe? If you don't mind, please. maybe 17-125. Oh, here we go. Do you see how the car is through the wall?
Yes.
I mean, do you dispute that the car ended up through the wall?
What do you mean?
Are you contesting the idea that the car ended up through the wall?
I never contested that.
Okay, so you agree with me, in other words.
Yeah.
Do you know how that happened? How these cars, your car, Mr. Echevarria's car, ended up through the wall?
Yeah, when he cut in front of me, we hit and caused the collision, the accident.
Okay, so the force of the impact caused your car and Mr. Echevarria's car to go into the wall. Agreed?
Yes.
Thank you. Now, in response to this crash, you ended up pleading guilty to 2 crimes, correct?
Um. Uh, I'm not sure if it was two. I'm not sure.
Okay, I'm gonna go over it, okay?
Yes, please.
Can we pull up 14-001, please, Joe? No. That can't be 14, can it? There we go. If you can pull up just at the top of the plea agreement. Well, yeah, there we go. Do you see that, what it says there, Zaon?
Can you read it?
Sorry?
Can you read it?
Yeah. It says oh, you can get up and, if you can't see it from there, or you can look at it in the binder as well.
I can see it.
You can see it? Okay.
Yeah, I just don't understand it.
The monitor on his desk doesn't work, or it's just not on? Can you turn that monitor on for me? Thank you. You should be able to, in just a moment, see everything on the monitor in front of you that we're seeing on the larger screens.
Okay.
And then it should prevent you from having to twist and turn. It's good?
Yeah.
Okay, thank you. Yes, still need that, yes.
It's tab 14 is what we're looking at, if you want to look at it, Zaon. Oh, you can put it on the
You
floor.
can
if you
move them
want.
out of the way. I'm sorry if that's what you're asking me, yes. Keep them up there somewhere, but you can push them way off to the side
Oh,
if you want.
can you see it now on your screen, Zaon?
Yes.
Awesome. Okay. Do you see where it says guilty plea agreement?
Okay, slight warning though, okay, that's not you touching the screen. If you put your fingers on the screen, it'll leave like a mark on yours, so just be careful touching that screen.
Okay.